The NLRB handles about 25,000 cases each year. Only 1/3 of the complaints are found to have merit, and of these cases, 90% are settled. Many charges are dropped after a contract has been successfully negotiated. Other cases are dismissed by the NLRB because they're trivial or because the NLRB does not have enough time to handle them. The NLRB faces a constant challenge to improve its efficiency since the full procedure from charge to complaint to hearing by a law judge to board ruling normally requires a full year. An unfair labor practice is any action by either the union or management that is prohibited by law or NLRB rulings. Every case originates in one of the regional offices as a charge or petition that has been filed by an individual organization. Unfair labor practice charges can be submitted in person or by mail, and they must be filed within 6 months after the alleged practice was committed. The regional offices of the NLRB investigate the charges by assigning a field examiner or an attorney to take written statements and affidavits from available witnesses. Regional offices try to dispose of the cases informally through withdrawal, settlement, or dismissal. If a case is not closed by one of these informal methods, a formal complaint is issued by the regional director to the general counsel. The general counsel may dismiss the case. This is the preliminary NLRB investigation and settlement agreements formal and informal procedure. Before complaints or a case goes before the full board, a formal hearing is held. An administrative law judge conducts the hearing according to the rules of the evidence and procedures of the United States District Courts and then issues a decision. Any party that disagrees with the judge's decision may appeal to the 5-member board of the NLRB. After the NLRB issues a decision, a dissatisfied party may appeal to the Federal Court of Appeals and then to the Supreme Court to review the case. This process may take several years. In a typical year, about 50% of the NLRB's rulings are appealed and approximately 85% of these rulings are upheld. Many of the unfair labor practice charges submitted to the NLRB arise from improper campaign activities, such as interference, restraint and coercion, threats of reprisal, promise of benefits, solicitation of grievances, restricting employee activities, surveillance and interrogation of employees, inciting anti-union activities, discrimination for exercising rights, discipline or discharge for union activity, and no solicitation rules. Prior to the passage of the Wagner Act, many companies established company unions for the benefit and support of their employees. These company unions, however, were run by management and did not serve as effective bargaining representatives of the employees. To eliminate this situation, the Wagner Act declared that company-dominated unions were illegal. Section 8A2 declares that it is an unfair labor practice for an employer to dominate or interfere with the formation or administration of any labor organization or contribute financial or other support to it. Therefore, companies are not allowed to participate or assist with the formation of or administration of any labor organization or to contribute either financially or non-financial support to it. Employers must use caution in creating quality improvement committees that include members of both management and labor. The quality movement has prompted many organizations to implement employee participation teams to improve productivity, quality, and efficiency. The effectiveness and importance of these committees is indicated by their continued use and popularity among both employers and employees. The NLRB has ruled, however, that these programs may be considered employer-dominated labor organizations, which are prohibited by the NLRA. When the NLRB finds an employer or union guilty of unfair labor practices, it has the authority to remedy the problem. 3 of its most common remedies include ordering the guilty party to bargain in good faith, reinstating employees who have been terminated, and issuing cease and desist orders. Okay, so we just looked at employee unfair labor practices. Now we're going to take a look at union unfair labor practices, strikes, and boycotts. As a general rule, employers can sue unions and their agents for unlawful conduct, such as violence and wildcat strikes, to the extent that they were involved. However, the courts have ruled that national unions are not responsible for acts of local unions unless they were actively encouraging them. Likewise, international unions are liable only to the extent that they also participated in planning and inciting unlawful conduct. Employers can also sue unions and their members for other illegal acts such as sabotage, destruction of company property, defamation, and injury. Employers may try to bring a cause of action against the union in either state or federal court, and if they succeed, they may recover damages for illegal union actions. What restrictions are placed on unions, and why is there a need to restrict the activities of labor unions? Unions are required to bargain in good faith with employers, and they are restricted from discriminating against employees who do not support them in the same way that employers are restricted. Unions may not coerce employees to support them or threaten, restrain, or discriminate against them if they refuse to join the union. Both employers and unions are restricted from coercing employees. Featherbedding refers to restrictive work rules that require more workers than are necessary to perform a job. The term comes from the beds on which firemen helpers slept after non-steam locomotives made their jobs unnecessary. The Brotherhood of Locomotive Firemen and Engine Men insisted the job was necessary despite its obsolescence and succeeded in preserving it in their negotiations. Although the Taft-Hartley Act prohibits featherbedding and this provision seems reasonable, it has had little effect. The Landrum-Griffin Act's requirements that unions adopt democratic procedures requires them to represent all employees in their bargaining unit, regardless of whether they are members of the union and regardless of whether they voted for the union. This duty of fair representation is intended to protect unions, even though most unions think it is unfair. If employers were able to negotiate separate agreements with those who voted against the union, they could offer better incentives and undermine the union. Therefore, unions are required to negotiate agreements and press grievances for all members of the bargaining union. The Taft-Hartley Act requires that both parties engage in good faith bargaining, or they will be guilty of an unfair labor practice. Both parties must be willing to meet at reasonable times in reasonable places to discuss each party's bargaining issues. A serious attempt must be made to adjust differences and to reach an acceptable common ground. Although the National Labor Relations Act focuses on protecting the rights of those who want to join a labor union, it also provides limited protections for all employees who want to act in concert regardless of their union status. Most employees are unaware of their protections. The NLRA grants all covered employees, including non-union employees, the right to engage in activity for their mutual aid or protection. The right to act collectively, to organize, and to discuss the terms and conditions of their employment among themselves. This includes the right to talk about what they are paid and to discuss employer harassment and discrimination. The right to criticize the employer and complain to customers, clients, or the media about the terms and conditions of their employment. However, an employer has the right to prohibit the disclosure of confidential and proprietary information. An employer may establish a formal complaint system, but it cannot punish or threaten to punish employees who choose to engage in protected concerted activity rather than using the procedures. The right to engage in a work stoppage. An employer violates the NLRA if it discharges or otherwise disciplines non-union employees for organizing or implementing a collective walkout to protest working conditions. While union members may be restricted from a work stoppage because of a no-strike clause in their contract, non-union employees have no such restrictions. The right to honor picket lines. Both non-union and union employees have the right to honor picket lines established by other employees. The right to solicit and distribute literature. Employees have a right to distribute literature and solicit support for protected concerted activities, although they may be restricted to soliciting during non-working hours and in non-working areas, which could be interpreted as coinciding with the times and areas allowed to solicitors for charitable causes. The right of access to company property. Employees cannot be denied access to company facilities and parking lots to engage in union activities unless they are denied comparable access for all other activities. The right to express angry feelings, even if they are intemperate, abusive, and inaccurate statements. An employer does not need to tolerate profanity, but there are differences of opinions regarding the protections for abusive language. While the NLRB struck down a rule prohibiting the use of loud, abusive, or foul language, an appellate court ruled that abusive or threatening language was not acceptable in organizing a union or exercising one's statutory rights. Unions are not allowed to restrain or coerce employees in the exercise of their collective bargaining rights. Therefore, unions cannot threaten anti-union employees with job loss should the union gain recognition. Picket line violence and threats to employees who cross picket lines are illegal. Threats of reprisal against employees subpoenaed to testify against the union at NLRB hearings are illegal. Unions are not allowed to force an employer to discriminate in any way against an employee in order to encourage or discourage union membership. Unions are not allowed to charge excessive initiation fees or membership dues when all employees are required to join a union shop. The NLRB has ruled that employees who are forced to pay union dues are entitled to know how their money is being spent. The NLRB ruled in January of 1997 that unions must supply financial information to workers who pay dues but who have elected not to join the union. The state of Washington also passed a state law requiring labor organizations to get permission from non-member workers before using mandatory dues for political purposes. Non-members are workers who have resigned from the union but are forced to pay collective bargaining fees, called agency fees, as a condition of employment. The teachers' union claimed that this law was very burdensome and it infringed on their free speech rights. In 2007, the U.S. Supreme Court upheld the state law and ruled that non-union workers can refuse to allow the money they are required to pay to the union to be used for political purposes to which they object. An economic strike is caused by disagreement over the terms and conditions of employment, such as wages, benefits, or work schedules. An unfair labor practice strike is caused by a condition of employment that violates one of the labor laws or an NLRB ruling. Strikes and lockouts generally do not occur as long as both parties continue negotiating. Even if an agreement hasn't been reached, if both sides feel that progress is being achieved, the strike or lockout will be postponed until the negotiations break down. Before the employees go out on strike, it's important for them to know why they are striking and whether the strike is strongly supported by a majority of the union members. A prolonged strike typically weakens the union members' loyalty to the union, and some long unsuccessful strikes have resulted in either the removal of the present union officer or decertification of the union. When the union leaders decide that the present proposal by management is not acceptable, they should also decide how much the proposal must be improved before they're willing to terminate the strike and come back to work. An assessment should also be made of the economic strength of the union, the company, and the individual employees. Before going on strike, union members should know why they are striking and what they hope to gain. Although strikes are usually called for economic reasons, they cannot ordinarily be justified economically. More income is usually lost during the strike than the workers can hope to recover through higher wages and benefits in a new contract. Here are a list of terms you should know. Strike, a refusal to work by a group of employees. Lockout. The employer closes the doors of the company and refuses to allow the employees to continue to work. Whipsawing. Successive strikes against members of a multi-employer bargaining union, usually starting with the most profitable employer, in an effort to use the gains obtained from one employer as leverage against the others. Secondary boycott, an illegal action that creates economic pressure on a secondary business, such as a supplier or customer of the primary business, and is thereby designed to create pressure on the primary business. Ally doctrine, an exception to the secondary boycott rule. When a neutral employer performs the work that was performed by the striking employee, it becomes an ally and may be subject to lawful picketing. Straight line operations are operations that are embedded in another employer's production process. Common situs picketing refers to picketing an employer who shares a common location with another employer. Employers who share a common location are permitted to establish separate gates for specific employers. For example, an employer that is being struck can be assigned one gate, and other employers not on strike can be assigned a different gate. This is called a separate or reserved gate doctrine. A wildcat strike occurs when a group of workers walk off the job in violation of a valid labor agreement and usually against the direct orders of the labor union. A sick out occurs when several employees claim they are not working because of illness. Employers dislike paying sick leave to striking workers, but they usually have to pay because it's extremely difficult to prove a prima facie case of the employee conspiracy. A hot cargo agreement is one that requires an employer to cease doing business with a non-union company. A jurisdictional strike results from a dispute between two or more unions over which union should be allowed to perform a particular job. Jurisdictional strikes are illegal. A certification strike is called by a group to protest the results of a certification election and to force the employer to recognize it rather than the union that won certification. Certification strikes are strictly illegal. If a company plans to close during a strike, it should notify vendors, clients, and others who will be affected. If it plans to continue operations, however, extensive preparations are needed. Some of these preparations include preparing a strike memo for all supervisors and managers explaining their specific responsibilities, teaching supervisors and security personnel their duties in maintaining the security of the physical plant and equipment and the safety of the people, and training supervisors and managers how to avoid unnecessary provocation and which laws apply to their conduct during a strike. Establishing a communication center and a command post, which could be simply a designated office with a telephone. Locating a warehouse away from the plant to store in-transit supplies, notifying vendors of its location, and keeping it staffed. Notifying the local unemployment office of the availability of job openings. Paying all money owed to employees on the first day of the strike. Posting no trespassing signs at appropriate locations and securing the facility, gathering evidence that may be needed in legal proceedings, such as names of picketers and a complete description of all picketing activity. Strike-related violence often occurs when replacement workers are moving into or out of a facility. Procedures can be implemented to minimize the opportunity for violence. Provide protection for replacement workers. Arrange for shifts to start at different times so workers are inside the facility before picketers arrive. Arrange for meals to be served inside the plant. Arrange for workers to stay overnight in the plant. Avoid contact with strikers. Provide transportation for workers from a central location. Collective bargaining consists of management and union representatives coming together to reach an agreement that will be acceptable to their constituents. The NLRB and the courts have classified bargaining issues into the following categories: illegal items, mandatory items, and voluntary items. Illegal bargaining items are issues that may not be negotiated at the bargaining table, such as yellow dog contracts, closed shop agreements, compulsory checkoff programs, and hot cargo agreements. Mandatory bargaining items include wages or salaries, hours of work, subcontracting, stock purchase plans, profit sharing plans, pension and employee welfare plans, Christmas bonuses, workloads and production standards, and plant rules. Labor and management must bargain in good faith on these mandatory items, and they may bargain to an impasse without violating the unfair labor practice provisions. Unions may strike to obtain mandatory items, and employers may refuse to sign a contract unless their version of these items is included in the contract. Voluntary bargaining items are issues that may be discussed at the bargaining table but may not be bargained to an impasse. Employers cannot make voluntary items a condition for signing a labor contract. Unions may not strike over voluntary items such as demanding that a company contribute to an industry-wide promotion fund or a strike insurance plan. Most labor agreements include 7 major bargaining issues: compensation and benefits, workers' compensation, job security, discipline procedures and individual rights, union security, contract duration, and management prerogatives. Most labor agreements have been negotiated between a single union and a single employer. What are the 4 kinds of bargaining structures? The 4 kinds of bargaining structures are single unit, single employer bargaining, multi-employer bargaining, coalition bargaining, coordinated bargaining, and national-local bargaining. The actual negotiations usually involve 2 teams of negotiators sitting on opposite sides of a bargaining table. At the local level, the union team often has about 7 members, including local officers, the union steward, and sometimes regional or national representatives. The management team is usually smaller than the union team, consisting of 3 or 4 members from human resources and line management. Top management often avoids participating directly in the bargaining sessions to reduce the possibility of making rash and unwise compromises. The bargaining process usually consists of 4 stages. The opening presentation of demands, where both sides present their demands. The union typically goes first. Management team asks questions to clarify the issues. The first meeting is especially crucial. The rules and procedures that will be followed throughout the negotiations usually are decided at the first meeting. Second, analyzing the demands. Demands submitted by each side. The negotiators have to examine each of the other's lists and try to identify which are the real issues. Unrealistic demands tend to antagonize the other team and to cause unnecessary deadlocks. The order in which the demands are discussed can become a serious negotiating issue in itself. Unions prefer to strike over the most important issues, and they like to have these issues discussed at the end of a bargaining agenda. When the interests of both sides are not identical, a compromise must be achieved. Compromises can be obtained by each side making counterproposals until an agreement is reached. After both sides have obtained what they feel is their best compromise, they have to return to their reference groups for approval. Top management must examine the tentative agreement and decide whether it allows them to operate the company efficiently and profitably. Union representatives have to decide whether the membership will ratify the contract. If the majority of those who vote approve the agreement, then it is ratified and becomes a binding agreement between the company and union for the duration. Distributive bargaining refers to a confrontational bargaining strategy in which each side battles to obtain the maximum amount possible. In essence, both sides are fighting over who gets the largest piece of the profit pie. Integrative bargaining is a problem-solving approach to bargaining in which both sides try to identify what each can do to increase the size of the pie and create a more compatible working relationship. The areas in which each side is willing to negotiate comprise the bargaining zone. Each side has a tolerance limit and will refuse to negotiate on issues that exceed its limit. Take a minute to look at the chart. You can see the bottom half is what is preferred by the employer, with the employer's tolerance limit at the top half. The union's preferred is higher than the employer's tolerance limit, and thus the bargaining begins. Some of the most important principles for effective negotiations include the following ideas. First, separate emotions and issues. Set priorities. Prepare thoroughly. Ascertain what is really driving the other side's agenda. Keep an open mind, never say never, and strive for a win-win solution. This is a great story. In 1980, Chrysler Corporation was teetering on the brink of bankruptcy in spite of receiving federally insured loans. The president, Lee Iacocca, told members of the United Auto Workers Union that Chrysler would soon have no $22 an hour jobs, but that if they agreed to his proposed wage concessions, they would still have many $17 an hour jobs. The union members accepted the wage reduction partly because the white-collar employees had made similar reductions. Iacocca's salary was just $1, and partly because it was obvious that the concessions were necessary to save the company and their jobs. The concessions won by Chrysler set a pattern for many collective bargaining agreements by companies that are struggling financially. Negotiations that result in wage reductions or work rule givebacks are called concession bargaining. The major economic factors that lead to concession bargaining include increased international competition, deregulation of key industries, and technical innovations. The reasons why union leaders are willing to accept wage reductions indicate that the most important motive is a belief that the concessions are necessary. An employer has a duty to provide information the union requests that is relevant to negotiating a collective bargaining agreement. This information might include labor costs, including wages, benefits, and pensions for union members, information pertaining to wage increases granted to non-bargaining unit employees, information about chemical substances in the work environment, and medical problems of employees. This is called good faith requirements. An employer has a duty to provide information the union requests that is relevant to negotiating a collective bargaining agreement. This information might include labor costs, including wages and benefits and pensions for union members, information pertaining to wage increases granted to non-bargaining unit employees, information about chemical substances in the work environment, and medical problems of employees. An employer does not have an unlimited duty to provide all information requested by a union. Some kinds of information an employer is not required to provide include information that would violate the privacy of an employee, information that would disclose an employer's trade secrets or confidential financial reports, information that would be prohibitively costly or burdensome to provide, and information the union requests in bad faith, such as information that is not needed for collective bargaining purposes or that will be used in a negative publicity campaign. An employer is not allowed to circumvent the collective bargaining process by negotiating directly with employees regarding mandatory bargaining issues. If either the employer or the union want to terminate or alter the conditions of an existing collective bargaining agreement, the initiating party is required to provide 60 days advance notice before the expiration of the agreement or the modification is to occur. The initiating party must also notify the state mediating services and the federal mediation and conciliation service within 30 days of notifying the other party. As a general rule, neither the employer nor the union is allowed to unilaterally change a provision regarding a mandatory issue in an agreement while it is in force without consulting the other party. When a new employer acquires a company with an existing union agreement, either through a buyout or a merger, the successor employer is generally required to recognize the existing union unless through a merger the bargaining unit loses its majority status. When an impasse is reached during collective bargaining, it is sometimes helpful to request the assistance of a neutral third party. Mediation or conciliation usually consists of having the third party listen to both sides, evaluate the conflicting issues, clarify differences, propose new compromises, and identify common ground for further negotiations. 3 different styles of mediation have been identified: facilitative, evaluative, and transformative. Facilitative mediation focuses on helping the parties achieve a solution by asking questions, identifying underlying differences, offering suggestions, and encouraging a calm and rational discussion of the issues. Evaluative mediation tends to be rather formal and legal in nature and is modeled after the settlement conferences held by judges. Transformative mediation focuses on resolving the underlying conflict between the parties and validating their feelings of worth and dignity. Transformative mediation focuses on creating empowerment shifts that create greater self-confidence and recognition shifts that establish greater openness and responsiveness. Under the Taft-Hartley Act, the President of the United States can apply for an injunction to restrain a strike when the strike imperils the national health and safety. National emergency disputes normally involve critical services or industries such as railroads, oil, steel, coal, and ocean shipping. The President can apply for a court injunction to restrain the strike for 60 days. If no settlement is reached during this time, the injunction can be extended an additional 20 days. How to maintain a non-union status. For most workers, the decision to join a union rests on two primary issues: economic advantages and the elimination of unfair conditions. There are three major reasons why people decide not to join a union. Some employees consider themselves professionals and believe they should join a professional association rather than a trade union. An increasing number of people disagree with the goals and activities of labor unions, and some employees identify with management. The two most effective strategies for maintaining a non-union status are to improve workers' attitudes towards the employer and decrease their interest in the union. You do this by treating the employees better than if they had a union. Grievance procedures provide a systematic process for hearing and evaluating the complaints of employees and tend to be more highly developed in union companies than in non-union companies because they are specified in the labor agreement. These procedures protect the rights of employees and eliminate the need for strikes or slowdowns every time a disagreement occurs about the labor contract. All right, here's a question. Why do organizations need both grievance and discipline procedures? And the answer, problems will occasionally arise. In a union organization, rather than having these differences of opinion settled by a strike or a work slowdown or continual labor unrest, it's better to have a grievance procedure in which the issues can be openly discussed and resolved. Problems are also likely to occur in non-union companies. A well-defined grievance procedure provides an avenue for employees to express their complaints and resolve their problems in a peaceful manner. On the other hand, a discipline procedure is designed to protect the organization. A good discipline procedure gives organizations a way to deal with problem employees. Problem employees who are willing to accept help and improve their performance should receive the proper kinds of encouragement and support. However, a good discipline system also provides a way for the company to terminate problem employees who refuse to be helped and do not respond to the company's disciplinary action. What are the typical grievance procedures found in union and non-union companies? Most unionized companies follow the same general procedures for handling grievances. Here is an example of a small company grievance procedure. You see in step 1, the employee talks to the union steward and the union steward talks with the supervisor and the employee to work things out. If that does not reap results, then the chief plant steward is brought in step 2. He or she then speaks to the plant manager or the industrial relations manager. And if they can't resolve the issue, then in step 3 it goes to arbitration. Here you see a map of a grievance procedure for a large company. The first step in most labor agreements calls for the complaint to be submitted to the supervisor. Some agreements require a complaint to be submitted in writing on a prepared form. Other agreements allow employees to express complaints verbally. Employees usually can request the presence of a union steward to support them. A vast number of worker complaints are settled satisfactorily by a simple discussion. In step 2, you see that an employee might not be satisfied with the actions of the supervisor. The grievance can be appealed to step 2. At this point, the grievance is almost always written. The employee is represented by the chief plant steward or business agent, and the employer is represented by the superintendent or industrial relations office. If the union is not satisfied with the decision of the superintendent or industrial relations office, the grievance can be appealed to step 3. Here the plant manager or director of industrial relations represents the employer and the union is represented by the plant grievance committee. Grievances that are not settled at this step may go directly to arbitration. Large corporations may have a fourth step in the grievance process where top corporate officers meet with representatives of the International Union to resolve unsettled grievances. The number of grievances that reach this level represents a very small percentage of the total. The final step in the grievance process is binding arbitration by an outside third party acceptable to both management and the union. Both parties agree beforehand to abide by the arbitrator's decision. Here's another good question. Why do non-union grievance procedures tend to be inferior to union grievance procedures? The union grievance procedure is more clearly defined so that employees know specifically how they will be processed and where to go for help in completing the forms and processing their complaints. Union employees feel greater protection against reprisals from the organization, knowing that a formal complaint system has been developed and that they will not be terminated for expressing their complaints. Union members know that even if management does not agree with them, as their complaints are processed through the grievance appeal procedures, a neutral outside party will eventually review the issues and render an unbiased judgment. To have an effective grievance procedure, employees must believe their complaints can be presented without a lot of hassle, embarrassment, or paperwork. Their complaints will be evaluated by a fair and impartial third party. They will not be fired or mistreated for submitting their complaints and pressing them to a resolution. This protection against being fired or mistreated is necessary for the success of both union and non-union grievance procedures. Most grievance procedures specify time limits for each stage of grievance processing. An agreement may stipulate, for example, that a grievance must be filed within a certain number of days after an alleged violation takes place. The organization is required to respond with a certain number of days at each stage of the procedure. The purpose of such time limits is to force both the company and the union to address grievances immediately. If grievances are resolved promptly, friction and discontent are reduced. And finally, to resolve a grievance, both management and union representatives must be willing to discuss the issue rationally and objectively. Both sides must desire to resolve the dispute and to seek a satisfactory solution and to give fair consideration. To reduce the number of grievances that are appealed, supervisors are encouraged to treat all complaints seriously, carefully investigate and handle each case, talk with an employee as soon as possible, correct the problem if the company is wrong, examine the labor agreement carefully and obtain clarification from the Human Resource Office if necessary, collect evidence and determine if there were any witnesses, remain calm, carefully examine all the evidence, avoid lengthy delays. When all the information is in, make a decision and communicate it. Arbitration is the process of having a labor dispute resolved by an impartial third party who examines information from both sides and renders a judgment. The parties agree beforehand to accept the decision of an impartial judge called an arbitrator. The enormous time and expense associated with litigation has prompted employers to pursue arbitration and other methods for resolving disagreement, such as alternative dispute resolution. When two parties are unable to peacefully negotiate an acceptable solution, the next step is to ask for the services of a mediator. The mediator examines both sides of the dispute and tries to help both parties understand the other and find an acceptable compromise. If mediation fails, the parties can agree to submit the issue to binding arbitration and promise to live by the arbitrator's decision. Question and answer. What issues are most frequently referred to arbitration? Some of the issues referred to arbitration most frequently include discharge and disciplinary actions, seniority and its application, leaves of absence, promotions and transfers, vacations and vacation pay, holiday and holiday pay, health and welfare benefits, management rights, union rights, strikes and lockouts, union security, wages and hours. The overall objective of disciplinary action is to remedy a problem and to help employees achieve success in their work. What are the differences between the positive and negative approaches to discipline? The negative approach to discipline focuses on punishing employees for past mistakes and is based on fear and threats. Punishment is usually severe and serves as a deterrent to the wrongdoing of others. The punishment is usually administered publicly along with a display of emotion and anger and is administered immediately and often capriciously. The positive approach to discipline focuses on eliminating future problems and creating effective employees. Past mistakes are used as feedback to help employees know how to change. Disciplinary meetings are typically held in private in a calm and rational problem-solving atmosphere, rather than in an emotional, anger-filled scene before other employees. Here's a discussion question. What is progressive discipline? And why is such a procedure called progressive? A progressive discipline procedure consists of a series of disciplinary steps that increase in severity from a verbal warning to a verbal reprimand to a written warning to suspicion to discharge. Such a system called progressive because each successive step is progressively severe. The most severe punishment is termination or discharge. However, employees are not terminated unless they fail to respond to earlier disciplinary actions that have attempted to correct the problem. Before taking disciplinary action, employers need to make certain that they know what happened and the relevant circumstances surrounding it. Discipline that is taken in haste may result in charges of constructive discharge and create great embarrassment to the company and its employees. All charges of serious misconduct, such as sexual harassment, bullying, and insubordination, need to be taken seriously and investigated carefully, even if the complaint comes from third-party sources. A system of administrative justice has evolved over time that is generally accepted in most organizations and formally adopted by collective agreement in many union contracts. The two basic concepts supporting administrative justice are due process and just cause. Due process is the disciplinary action must follow an accepted procedure that protects an employee from arbitrary, capricious, and unfair treatment. And just cause is disciplinary action should only be taken for good and sufficient reasons. The following principles describe some of the most important elements of an effective disciplinary system: definite, policy, and procedure, supervisory responsibility, communication of rules, burden of proof, consistent treatment, consideration of the circumstances, reasonable rules and penalties, and statute of limitations. Employees have Weingarten Rights only during investigatory interviews when a supervisor questions an employee to obtain information that could be used as a basis for discipline or asks an employee to defend his or her conduct. Management is not required to inform the employee of his or her Weingarten Rights. It is the employee's responsibility to know and request. What is your homework? Finish reading Unit 5, listen to Unit 5 Part 2 lecture, take Practice Exam B for Unit 5, and memorize your flashcards. Don't forget to email me at info@trainmetoday.com or call 951-926-2644 or post your questions on the site. Thank you for listening. This concludes this lecture.